Welcome to the National Center for Technology and Dispute Resolution's ODR Cyberweek 2023. Today, we're going to have two tech demos. One is by Scott Seidewitz, No Humans Needed, Resolving Divorce Disputes with AI from BlissDivorce, and Going Upstream, How Understanding Contracts Can Avoid Conflicts with Otto Hanson from Screens.ai. I'm the moderator today, and I'm the director of NTCDR. I'm Leah Wing, and I am very excited to hear both of these. And as part of being upfront, I will just say that I have had the pleasure of being on the advisory committee for BlissDivorce for a couple years, and excited to see the progress around that, as well as the Screens.ai work contributing to thinking about how AI can assist us with resolving disputes. So without further ado, I'm going to turn it over to our guest speakers. The plan for today is that each one of them will share, with Scott going first, and be happy to take questions after. Feel free to put comments and questions in the chat, and then Otto will follow that. So thank you. And you can find their bios and more information about both of these platforms by looking at the program agenda and the links there. Scott.
All right. Thank you so much, Leah. My screen sharing working?
Yes.
Okay, excellent. Well, I am honored and excited to share our technology with all of you. I have to say, I don't usually start out when I'm speaking talking about myself, but in this case, I do feel a little bit like a fish out of water. So I just wanted to say, what is a guy trained in business at MIT, then in consumer marketing at Procter & Gamble, and who spent the last 20 years advising pharmaceutical and technology companies on marketing growth strategies? What am I doing speaking at an ODR conference? And so, the way I got into this legal tech field is LegalZoom was one of my clients. And I got a glimpse there at what the process of divorce is like. And to call it painful is an understatement. And I'll just share a little bit of information about it. I think we all have an intuitive sense of this. First of all, the average cost of divorce being between $20,000 and $32,000, depending on the circumstance of your divorce. For most families, that wipes out most of the family savings. It's a drawn out 11 to 15 month process. It is, by the nature of the process itself, it's high conflict, very stressful. And there's a great study from Ohio State University that took a look at matched sets of two sets of families, 9,000 families in both sets, and looked at what happened for families that had been divorced versus families who had not been divorced, that were the same in every other way. The families that had gone through divorce had 77% wealth. And I think that's really a testament to how traumatic this experience is right now. That was really the impetus for us to come up with a way to not just revise this system, because, the way that divorce is done now, both sides hiring two lawyers, there you can see on the left, is not that much different than it was done 200 years ago. There's been, there's some spreadsheets used now, but there's no fundamental differences. We didn't want to reform this system. We wanted to find a way to rethink, reimagine, and replace this system. And that's what BlissDivorce is about. Now, to do that, we came up with some design principles, 5 design principles. The first principle was, we had so many people saying, hey, I'm a mediator, let me tell you how you can do this. Or I'm an attorney, let me tell you how I can do this. We decided very early on, we're not trying to replicate human processes. We needed to think of something new. Number 2 design principle is, any kind of dispute resolution happens in the context of an experience. And we really wanted to invest in a user experience because divorce is such a traumatic experience. We wanted to try to help users through it by the design of our software. Principle number 3, we need to be very careful about not practicing law. So we provide information. We make a point of saying we provide information to empower you to make a decision. We cannot provide advice. Always saying that. Then one of the things that our advisors, especially Leah, really put in our heads, because we hadn't thought of this in advance, is the best way to resolve disputes is not to have them in the first place. So we designed our customer experience to try to avoid disputes. And then finally, there's a lot of legal tech out there that's about enabling the current system, enabling lawyers, enabling mediators to work more efficiently. That's not what we were trying to do. We wanted the tech to resolve disputes. We want to disintermediate humans. We have customer support, but we didn't want to be dependent on humans as we scale to actually resolve disputes. So those are our 5 design principles. I'm going to go into depth and actually demonstrate to you what we did for these 3. The invest in user experience, the way that we avoid disputes, and then especially the technology to resolve disputes. Now, investing in the user experience itself, we did all this work early on with personas and empathy maps and journey maps. And frankly, our chief technology officer, Dan Hirsch, who joined us from Intel and from a couple other startups, is an expert in all this stuff. And he led us through it, which was fantastic. But it led to this, I think, user experience that we're very proud of. Let me just pull it up so I can give you a quick sense of it. So here is our website, BlissDivorce, our external website. Once people sign up, you can sign up for free, but I won't get into our business model. What they sign up, they have to go through a little onboarding to understand a few legal principles, and then they get to here, which is their dashboard. And you can literally handle every aspect of your divorce from the dashboard. Here are the 6 modules we have. Actually, the home module is right now implicit in the investments module, but we will break it out. Personal possessions, debts and other obligations, child custody agreement, child and spousal support. I'll just click on one of these. You can see you can come in here. I've got 1 account entered so far. You can add an account by importing it if you like. We have a integration with what's called Plaid. You can import things directly from your bank, from your financial institution, or you can enter it manually. You can see we handle pretty much all aspects of a divorce, from all kinds of banks and investment accounts or investments, personal possessions, debts and obligations, child custody and parenting, and child and spousal support. So that just gives you a quick flavor for our user experience. There's guidance as they go. In any case, I'm going to leave it there so we can keep moving on. So that was the first thing that we really invested in. It's having a user experience that is comfortable and easy for people going through a difficult process. Then the next thing was we designed that customer experience to actually avoid disputes. Sorry about that. I thought I had turned off my notifications. I'm not even sure where that's coming from. It'll go away. I apologize. I think it's because of my Apple Watch. So the 3 things that we do to try to avoid disputes are: 1, provide information; 2, we have expert systems, and even the design of the language on our site in our application helps to avoid disputes. There, that's gone. Let me also show you this very quickly. There's where that was. Sorry, it went to that. Okay, so let's take a look at an example of if you wanted to, so part of what users do is not only disclose assets, but they say how they're going to divide them. Early on, this is an example of avoiding disputes. Early on, we found that people were, one would say it's community property, the other says it's separate property. That has to be in alignment for us to prepare an agreement. So we created a widget to help them decide. They just go through these questions: whose name is on the account? Me and my spouse, therefore it's community property. Actually should have, let's see, let me try that again. Help me decide. My spouse only, was it before the date of marriage, after the date of marriage? That also can decide it. Where did the funds come from? So again, it's just a series of questions. Once they have this, they can still decide what they want, because again, we're not practicing law, but the number of disputes went down dramatically. I'll show you one other thing very quickly in child custody. First of all, you can see, actually, I'll go back 1 screen. We don't talk about physical custody and legal custody, which is how our advisor said to present this. As soon as we started talking about custody, parents started saying, I want full custody, and we had a dispute. by changing the language and talk about what they needed to agree on, which is living arrangements, really, not physical custody, and decisions about school health and other welfare decisions, disputes went way down. Then even the language in our area here for living arrangements, we talk about the living schedule and what they need to deal with. They can choose different schedules. They can go in here and work out all the different holidays by getting them focused on the task as opposed to the thing that leads to dispute, who gets the custody. We found disputes went way down. So there's an example of the use of language really helped reduce disputes. So that was design principle number 2, avoid disputes. I tried to go through that quickly because I wanted to make sure we had time for what I think is our biggest thing, our biggest secret sauce, which is the tech to resolve disputes that still remain after avoiding. So, we looked at existing dispute resolution systems, and there are some fantastic ones out there, but we didn't think they were really, the type of dispute resolution that we needed. Plus, we needed something proprietary. And I'll tell you, early on, when we had Leah and other advisors, we looked at all kinds of different things, from game theory to negotiation, voting systems, even computational logic. Where we netted out were these 3 areas. Number 1, techniques for value attribution. Any way we can understand what's important to each of the parties in a dispute and where those importance levels differ, we can then algorithmically see how to divide things that both sides might be willing to accept. Then the strategic use of knowledge. As we learned that community separate property is an example, as we learned, although I'll share another one here, but as we learned specific things, as we were in the market learning, we found out, hey, there are certain things that are caused by just people not understanding things properly. So another way to resolve disputes is just, in specific instances, share information. And then finally, you'll see, to resolve disputes whenever there is a monetary need, really for spousal support, we have leveraged pricing research. I'll explain that in a minute, what's called the Van Westendorp price sensitivity meter. Let me first demonstrate for you how we're assessing value attribution and an example of how we're using strategic use of knowledge. I will go back over here. So this is an actual, one of our actual dispute resolution surveys that we send out. We've blinded the name, but this was actually used. So the way our dispute resolution process works, they go through our platform. Our platform identifies areas of agreement and disagreement. To resolve the disagreements, each side is sent one of these surveys that goes through the questions that we need to be able to plug things into our algorithms to propose resolutions to their disputes. We, of course, make them agree that we're not practicing law. They have all the rights to make whatever decision they want. This is an example, actually, of strategic use of knowledge. We know that 90% of the time, when both spouses want the asset to go to one spouse, let's say in this case, they both wanted the asset to go to Jen, I think it was. But one spouse says it's community property, the other says it's separate property. It's almost always community property. We've just seen that through our early cases. And that's because one spouse is just saying, oh, it goes to me, so I'm just going to call it separate property. Usually when we just explain that what separate property is and they can still get the asset, even if it's designated community property, almost 100% of the time they change the designation. So there's an example of strategic use of knowledge. But let me also get to when we have disagreements on division of assets and debts, where it's not just whether it's community or separate property. Here's an example of where we use a value attribution technique. Now, we have techniques like point allocation, where they might take 100 points and spread it across the different categories of assets, or even getting down to the individual assets. We have a more sophisticated technique called discrete choice modeling. It's based on decision choice theory. It's where they look at a series of groupings of compromises, and they might see 3 or 4, and they have to pick one each time. And through doing that, we can statistically model how much utility they assign to each item within the agreement. But that's really complicated. We always try the simple first. And this is an example of where a very simple technique worked. We got the information, we plugged it into the algorithms, and it came up with a resolution that I'll show you that both sides agreed to. In this case, they had 6 categories or 6 classes of assets. One spouse said the home was most important to them, and then, these other things and so forth. The other spouse said they actually had a plane. And the other spouse said, what's most important to me? I want that plane. Home is number 2, and so forth. The other thing that we asked them was they both wanted more than 50% of the community assets. We asked them, what were they willing? We let them know the range. They didn't know how we came up with this range, but it was basically the range that what they had proposed versus what they spouse proposed they get. And they had to put a percentage in there. Fortunately, both put in 50%. With simply that information, there was a little other information we gathered, but with simply the ranking and what percentage of the assets they were willing to take, we were able to come up with, let me make sure this is the right one. Oh no, this is hold on one second. We'll go to this one. We were able to come up with, this is the report that they're sent. This is generated just by going through the survey. They resolved 12 issues, summarized their preferences and what the remaining issues were. We won't get into the child custody issues. You can see it describes the compromise proposals and what goes into them. And you can see they didn't have, this was not a simple divorce settlement. They had more than $2 million in assets, $1 million in debt, or 800 some thousand dollars in debts. We've handled divorces with up to 3.5 million in assets. But you can see here, the key was one side wanted the house and the other side wanted the airplane, and everything else got split up according to how they had put it in the platform with a few constraints. We try not to split up retirement accounts because there's extra cost to splitting those up. But we gave them a few compromise proposals. They got to choose between them. What was great was basically they chose one of these. One of the spouses chose one, proposed it to the other. There are a few properties that they owned. The one thing we couldn't resolve through this process was how they were going to manage those properties after their divorce. So they had an hour and a half of mediation to work that out. That was the only human involvement. But otherwise, the algorithms and the technology were able to work this out. I also want to very quickly show you what we do when there's a disagreement in support issues. Now, there we need to get to a number. And in that case, we've brought in and borrowed what's called the Van Westendorp price sensitivity meter. My other firm, the Seidewitz Group, uses this technique sometimes, although frankly, pricing research has moved on from this. But it's a way to gauge ranges of prices that consumers are willing to accept. You ask questions like, what price is too expensive? What price is expensive you'd be willing to buy? What's a bargain? What's too low? We took those questions and adapted them for use in dispute resolution when it comes to the amount, term, and tapering of spousal support. Actually, we let them type in free text field. Is there anything they'd like to explain to their spouse? We found that can be helpful. We run that through generative AI to try to kind of take any of if there's conflict in what they've written out. But then we asked them a series of questions very similar to the Van Westendorp pricing meter. What monthly spousal support amount would make it too hard to pay your bills and maintain your current standard of living? This should be the amount below which you just couldn't get by. Then a question more about what would make it difficult, but you'd be willing to consider. And finally, what would you be comfortable with? And we found that spouses usually are willing to be somewhat flexible in answering these questions so we can resolve the dispute. And it's programmed to force them to make each one be sequentially more than the other or less than the other, depending on, which spouse it is. Anyway, we also use there's another technique here that we're using, which is just trying to estimate and forecast how much support that they need in order to become self-sufficient. Both sides gets to do it. We use an algorithm then to kind of do a weighted average. But then we go back through the Van Westendorp types of questions. Coming out of here again, a report is generated. You go to this report. In this case, again, we summarize some of the information that was input, and then we go through the compromise options that, all the data is plugged into algorithms. The algorithms output the possible compromises. This was another interesting case. One spouse proposed to the other this compromise number one that defines the amount, term, and how much it tapers over time. But the other spouse, that was the paying spouse, said, well, this was above his budget, and proposed back, and we cut that down a certain amount, but we'll reduce the tapering so it stays at the same total amount. And they were in agreement right away. So it wasn't exactly what the algorithms proposed, but it enabled them to come to an agreement very quickly. That gives you a good flavor for our technology. I'll share the results very briefly. In our first 40 cases, or MVP, we had mediators on every case. This is how we learned. This is really how we took the theory and developed the first set of algorithms that then we started applying in those cases. But in the next 20 cases or so, we were able to dramatically cut the amount of mediator time. There was an average of probably 4 or 5 hours of mediation in the first 40 cases. We probably got that down to 2 or 3 hours. The last 20 cases, we've needed a mediator, I believe, on 2 cases. There's been almost no mediator involvement. I explained how it's really just when there's an exception or some unusual circumstance that we need to bring a mediator in now. And now we're really at the case we're ready to invest and start to grow because the technology is really working. We need to automate a little more of it, but I'm going to skip these slides for time, how we're using AI, our roadmap for using AI, and just take this opportunity to say, I think when it comes to innovation in legal tech, we really need more technology that empowers legal consumers and disintermediates legal providers like BlissDivorce is doing. I think this is because the current system truly is not serving consumers. People can't afford, the vast majority of people can't afford legal representation. And then most systems, I went through a legal process for the first time in my life recently where we had to sue a landscape provider, and I could not believe how drawn out and inefficient it was. We really need new systems and processes to replace and reform what I think is a massively inefficient system. As a business person, when I saw how it worked, and when we look at divorce versus the traditional system versus how we shepherd people through the process in a few months instead of a year, our biggest hurdle is just getting consumers to trust and adopt the technology. I think if we can all get together and say, we should be focused on empowering consumers, not lawyers. We need to reimagine and rethink a massively inefficient system and really invest in getting consumers to trust and adopt legal technology. I think it's going to be so much better for consumers and society. And I really hope we can focus on these priorities. And that's what we're doing at BlissDivorce. So thank you very much. That's my presentation.
Thank you, Scott. Perfect timing. Maybe we can take about 2 or so minutes now. It'll be brief, but we can also stay a little after if anyone wants after the hour to engage further. But I want to welcome questions or comments. You can put it in the chat, or you can feel free to just raise your hand and go for it.
Come on, you guys can't be so impressed that there's no question.
Well, I'll go if no one else is going to go, and I'll start off by saying how impressed I am, but I won't take up too much of your time with that. One thing I'll just say, one thing particularly that I liked was doing when you said how you had broken custody down, or first of all, away from the legal term, and broke it down into its components, which are parental components as opposed to legal terminology. Right. I love how you technologize that. Working as a mediator, that is something, of course, I would would often do. I'd say, no, let's not talk about custody. That's it, right? Let's talk about parenting. Let's talk about time, talk about living arrangements. Let's talk about decision making. That's what we need to talk about. Your parents, you're not, outside of, you can be parties if you take it to court, but here are your parents. Let's talk about that.
Right.
So, technologizing that is very admirable. I was wondering, I'm wondering a lot of things, but I'll just ask one thing to give you an opportunity to say it.
Sure.
So divorce costs a family $20,000 to $30,000 a year, and on the average end, or if you're not in Hollywood, what is your fee?
Oh yeah, absolutely. No, we have plans that start at $1,500 if there are no disputes and they just need us to do the paperwork, because after we resolve all the disputes, we also prepare the paperwork for them and take them through the paperwork process, which people are shocked is a multi-step process because nobody understands divorce. 1,500, 2,500 if you just need digital mediation, 3,500 if you also need to have a mediator. We almost never have anybody using the 3,500 plan these days because the technology is working so well.
And do they decide that up front, or they decide that on a one stage to another basis?
Yeah, after they go through the platform, when they're ready to pay and they have a sense of what their dispute level is, they need to pick a plan. But we let them also upgrade if needed.
Great. I just wanted you to put that comparative.
Yeah. No, thank you. Yeah, no, it's a huge cost savings.
Any other last question before we move on to listen to Otto?
This is fascinating and just wonderful and about time. Now I'm not a family mediator, and I've been working with the court system, but this is tremendous. I want to be able to refer, so I would like that information. And I was thinking, once I start, I need to get training in family mediation. I haven't done that yet for personal reasons, but I can see this being so widely used, but a lot of people aren't aware of it. Are you advertising, or is it word of mouth you rely on? Because I definitely would recommend.
No, thank you. We're only on the market in California right now. We're proving our case in California, then we will expand in other states. But Tina, you should think about, to the extent that we need mediators in the future, you should think about becoming one of our mediators. And even if you're out of state, you can mediate in California.
I would do that. And this just makes sense, because when you're going through a traumatic experience, the one thing you really need is clarity. And the way this is really broken down for the end user is brilliant. So thank you.
Thank you very much.
You're
welcome to get my contact info from Leah, and I'll also. Oops.
Oh, I do it in a heartbeat, because this is what people need. It really is.
Here's my contact info down here.
Wonderful. Well, and this is the benefit of having a chance to engage in the conference-like forum that's open to the public and also be reposted, so that practitioners can get connected to technology that will work, can get employment that way, and also can spread the word to people that they work with. Thank you, Scott. Let me turn it over now to Otto, who has another exciting platform to tell us about.
Great. Thanks so much, Leah. And yeah, awesome work, Scott. That is such a great platform. I hope never to have to use it myself. But I'm certainly glad to know that for the millions of Americans that do go through divorce, that there is a game-changing technology coming out. And I love Noam's comment too. Your use of language and the focus on language to just guide the process is just so cool, and something that we haven't spent a lot of time thinking about. But one lesson I've learned from you and your presentation about how important that can be. So thanks for.
Well, thank you. Thank you, Otto.
Okay, well, I'm going to share my screen, and we're going to talk about now, for the remainder of the hour here, we're going to go into an interesting conversation about going upstream in the conflict resolution process, and a topic that's near and dear to my heart for reasons that will become clear in a moment, which is how understanding contracts can actually help people avoid conflicts in the first place, and potentially resolve them quicker, faster, better in the second place. So that's what we're going to talk about. I'll introduce myself and then share an agenda. My background in a nutshell is I'm the founder and CEO of a company called TermScout, which is a B2B contract AI company. We've been in business for about 5 years, and we serve companies like big tech companies, basically. IBM, Lenovo, Siemens, Figma, Canva are among our many customers. It's a very niche B2B contract AI company. I'll talk a little bit about it in a minute because we learned something very interesting. My second venture is the one I'm going to talk about today, which is a new venture that we're building called Screens.ai. And Screens is a consumer-facing, in large part, a consumer-facing contract review solution. I'm a licensed attorney. I worked in tech transactions, and I think that's a good enough background for me because you're going to hear a little bit more about my story in just a minute. By way of agenda, I'm going to break my piece up into 3 sections. The first is a bit about why we are here, we as in TermScout and Screens, why we're doing what we're doing, why we think it's so important in the world. The second piece I'm going to talk about is why now with Screens, the consumer-facing version in particular. And then the third piece is how do we actually solve this problem that we're going to learn about today. And for that, I'll jump right into the new web application that we're building, Screens, and do a tech demo. Feel free to interrupt if anybody has a question, if anything is unclear. I think we've got a small enough, intimate enough group that if you, I won't be monitoring the chat, but if you do want to interrupt me verbally, you're welcome to do so. So let's start with why we're here. And for that, I'm going to tell a little bit of a story about my background. I practiced transactional law, and I went into transactional practice from law school because I believed that transactional law seemed like a place to build a practice that was going to be collaborative rather than confrontational. I thought, gosh, I really want to help people find a deal, and transactions, this is like a whole half of the field of law that could be used to help people avoid conflicts and craft, terms and conditions, contracts that actually like serve the purpose of the deal better and help people develop rules and guidelines for their transactions. And that seemed really exciting to me. And I was wrong about that. It is actually not a very collaborative space, perhaps no more collaborative than dispute resolution or litigation, it turns out. And I learned this, everything for me changed. My perspective changed very, very dramatically one day when I was practicing, when one of my clients, a CEO of a consumer-facing app, like an iPhone app, that was just going gangbusters. It was super, super popular. The CEO of this company, he calls me up. I'm his lawyer. He says, Otto, we just looked at the data, and what we learned is nobody ever reads our contract, the terms and conditions that we ask them to sign, that people just scroll through mindlessly. He said, nobody ever looks at it. The data is really clear. And I said, yeah, I know, it's a crazy world we live in. All of us are signing contracts blind. And he says, yeah, so what I want you to do is redraft our contract and make it super one-sided. He said, I want you to basically gouge our customers' eyes out. If they're not going to read these terms, we might as well make them. We win, they lose. I want to be able to sell their data to the Russians. I want to make sure they can never sue me no matter what goes wrong. And he goes on and on this list. And I'm like, holy smokes, this dude is bad. Like, this is just an ugly attitude to have in the world, in my opinion. But I didn't have much of a rational response. And as I zoomed out of that one little anecdotal moment, and I started to look at all the other transactions I was working on, I realized that this guy wasn't actually the exception. He was the norm. And what I realized was in the B2B world that I was working on, which is a lot of B2B software deals, you had this very, very common fact pattern. The vendor would say, hey, customer, let's work off of our contract. Here it is. And the customer would say, sometimes the customer would say, nah, let's work off of our contract. And when somebody gives you a contract, you have a huge information asymmetry problem, right? I have no idea. It's very, very challenging to figure out, is this thing really, really bad or really, really good? And what I realized when I was practicing is actually, as soon as you'd open them up, more often than not, you'd find out, wow, the vendor's proposed terms are super vendor favorable. And the customer's proposed terms are super customer favorable. Everybody, in other words, is taking this opportunistic approach to their contracts because we live in a world that's so inundated with contracts. And because you need a lawyer intermediary to help you understand whether a contract is good, the contract drafters of the world have said, hey, here's an opportunity for us to gain some advantage in transactions. And fast forward the clock a little bit. Actually, before I get there, what to me, the answer seemed very, very clear. I was like, gosh, well, what if we could build an AI that would let you look at a contract and immediately understand which one is naughty and which one is nice? And that's what we've been building at Term Scout for the last 5 years, very focused on the B2B space. And what we've learned is we developed a proprietary rating algorithm that does exactly that. It files every B2B software contract into one of these 3 buckets, basically. Tons of data to back this up. I won't go into the details about it because I don't want to focus on Term Scout today, but suffice it to say, we've analyzed thousands and thousands of B2B contracts now, and the data is very clear. Those anecdotal experiences that I had are actually the norm. And what we found is 55% of all B2B contracts are very vendor favorable. 32% are, balanced, reasonable. And then only 13% are actually customer favorable when you're looking at the vendor's starting position. So the vendor's form of agreement. So this is B2B, by the way. And B2B, we know, is much more favorable to the customer. Like if you're a business, you're much more likely to say, let's give our business customer a reasonable contract, because guess what? They have counsel, right? Most businesses have an attorney to review them. When we apply this opportunism, when we start to look at consumer contracts, the calculus is different. And this, to me, what this graph shows is much less about B2B or B2C and much more about human psychology. And the fact that we humans are opportunistic creatures, and we will and often do, make moves to gain advantage wherever we can, especially when we think our customers may not look or notice, which is the case in contracts. All of that is to say that some contracts in this world are good and some are not. And knowing the difference, we believe, is the first step to leveling the playing field, empowering consumers, and avoiding bad relationships. Okay, so that's the why. That's why I came and started working on these problems and why we're here solving these problems. Let's talk for a minute about why now, and then I'll jump in and actually show you what we're building and how it works. So why now? Pretty simple. LLMs, large language models, GPT-4 Turbo actually just came out on Monday, and it looks so amazing. But LLMs have passed the bar exam. They're capable of extremely complex reasoning. They're accessible virtually everywhere. ChatGPT, CLMs, lots of free applications. All of us can go access really cutting edge, state-of-the-art large language models. And large language models, today's large language models, can solve most contract review problems. That's a bold statement. We have a ton of data to back this up. This is really what we've been working on since GPT-4 came out in March of this year. We have been heads down testing this particular hypothesis, and it is very, very true. The large language models really can understand contracts at an incredible level of accuracy. With a big if you can write great prompts. You've all heard the phrase garbage in, garbage out. If you draft a bad prompt, if you ask ChatGPT, is this a good contract? It doesn't really know how to answer that question. And it actually fails miserably 99% of the time because it doesn't have the background, the context that we subject matter experts have. It's not that good at knowing what to look for in this particular type of contract, in this particular set of facts, etc. So if you write bad prompts, if you put the prompt piece in the hands of consumers, what we think is you're going to have a really hard time empowering consumers to understand contracts. But if you draft great prompts, you can get magical results, really, truly magical results. And again, this is what we're testing, and this is what I'll show you. So, so that brings me to the last portion, which is the tech demo. How do we solve it? And I think I have a couple slides here to just set the table, and then I'm going to jump into the app and we'll go look at a contract together and talk about how the technology works and answer any questions about it. So first, what the heck is Screens, this new app that we're building? It is a new platform by Term Scout that lets users build, test, and perfect a screen for any type of contract review project. Now, a screen itself is a set of questions and standards that are drafted by a subject matter expert that helps somebody apply those questions and standards to any contract they're looking at and figure out essentially what would that subject matter expert who prepared this screen, what would they think about this contract that I'm looking at, okay? And once a subject matter expert has created a screen, they can share it with the community. So Screens is the first AI contract review platform that's driven by communities of experts. Any expert in any particular field. So if you have a landlord-tenant expert on leases, they can go build, and that's what we're going to look at today, they can go build the consortium, the predatory terms in leases screen for consumers to use to review leases. Privacy policies, an expert on privacy policies, and so on and so forth. Our hypothesis is this: if we can pair subject matter experts with today's hyper advanced large language models, we can make magic happen, and we can help consumers quickly look at a contract of any type and immediately understand from the perspective of a true expert in that particular type of transaction. Is this contract super naughty? Is it like that client of mine who took the very nefarious opportunistic approach? Or is this actually a pretty reasonable contract, a reasonable company or person that I'm going into business with, in other words? So that's our hypothesis. And let me jump in now and show you how it works. So the starting point is the community that I mentioned, and it's super lightweight. By the way, we only launched the beta version of Screens about a month ago. We've led about 80 people into it. It's in kind of quiet, we're rolling it out. We'll officially publicly launch this platform in January of this year. But for now, we're building it as we go, building the airplane as we fly, as they say. And so the community is lightweight right now, but it's a great place to start. In the community, we have experts who have gone in and built a handful of screens to get people started. And you can see some of these are B2B, some of these are B2C. I've got one here called Prohibitive Terms in Colorado Leases. And when you click into it, you can download this screen and open it up in the Screens app. So I've done that already to save us a little bit of time. And I've got that here. We're now in the Screens app. Super simple, like pretty standard web app interface. You've got kind of two little modules on the left here, your screens. These are your sets of questions and standards that you can apply to contracts, and your documents. And then you've got an organizational system called Labels, which lets you kind of categorize your screens and the like. So I've got lots and lots of screens in here that I've built. But today, what I want to look at is my screens associated, or screen in this case, associated with residential leases, a consumer-facing screen to help consumers in Colorado analyze a lease. So let's go look at it. First thing you get when you open this up, by the way, there's a free version of the Screens app. There always will be a free version of the Screens app for consumers to go in and use the app for free to analyze high-stakes consumer contracts. So what they'll see when they get in there is, the first thing they'll see is a description. So kind of who is this designed for, details, AI accuracy, validation metrics, and the like. And what this screen is about is, this one was built using Colorado revised statutes. There is a law in Colorado that prohibits certain clauses from being put in a lease from a landlord in Colorado. Those clauses are listed here. Basically, leases in Colorado are forbidden from having a waiver of a jury trial. That's forbidden in Colorado, turns out. They can't have a waiver of a right to class action claims. You cannot waive the implied covenant of good faith and fair dealing, right? In all of these, you've got user guidance that cites to the specific section of the law, in this case, that this standard was created off of. But basically what we've done is had a subject matter expert who knows this body of law really well go in and create this screen. Now that it's created, it's live on the community. Anybody for free can go download it. They can add standards if they want. They can modify this. They can add questions to it. And then they can go and screen a document. So again, I just screened one this morning, and we can go take a look at what the results look like. So this is a residential lease that we pulled, and we can go look at the results of this particular lease and basically quickly understand, does this lease, is it likely to violate any of the provisions of the Colorado revised statutes? And what we see quickly is it appears to actually violate two of the provisions this one looks a little naughty. And when we, on the Screens platform, one of the things that we've learned is super, super important if we're going to build technology to help people understand contracts. One of the fundamental core principles that we follow is a principle we call auditability. It needs to be really easy for someone to be able to audit the results of the AI. Why? Because while it's extremely powerful, it's not perfect. Neither are we humans, by the way. But the key is make it really easy for users to double check the AI's work. So that if an attorney is working with you, or you're in dispute resolution and you've got a mediator or somebody looking at this, you can get an initial read. Looks like most of these standards are passed in this particular lease, by the way, but we've got two that apparently are a fail. So the first one is the standard that the agreement should not contain a waiver of the right to a jury trial. So we're going to audit the results, right? If we're thinking about signing this, if I'm a consumer in Colorado thinking about signing this, I want to audit the results. If we're in a dispute resolution situation, I want to make sure that the AI is right. So when you go into the learn more to audit the results, you get two things. First, the AI creates its own, generates its own reasoning. What it says here, by the way, I could zoom in maybe a little. What it says here is the document contains a waiver to the right of a right to a jury trial, which is against the requirement. Nice, concise, crisp statement. And then what we've got is a pinpoint citation to the specific language within the contract itself that proves the veracity of the statement. Doesn't always prove the veracity of the statement, but that the AI thinks is the most relevant section of text to help you determine whether or not the AI got it right. And if we look at it here, landlord and tenant, this looks right. Hereby waive their respective rights to a jury trial. So before we publish a screen to the community, we go through a process called validation. And what that means is we use the screen on lots and lots of sample documents, and then we tell the AI whether it got it right, and we track it. So here I'm going to say, okay, I've validated this result. We've got 100% accuracy on this screen right now on a sample size of only one document, but now we're getting the Screens platform to actually track the validation stats over time. So as we start to develop more and more community screens and validate them more and more, we'll have larger and larger sample sizes that'll help us hone in on that core principle that I talked about earlier, which is the principle of writing really great prompts to get the AI to perform with high levels of accuracy and specificity the precise task that you're asking it to perform. So I validated the result. We're looking good here. We've got one more fail that we're going to want to look at. And we'll do the same thing. No fee shifting clause that awards attorneys fees and court costs to only one party. So it says, again, we found a fee shifting clause for one party. And if you look here, it looks like if legal action is taken by the owner to enforce this agreement, owners shall be entitled to all costs incurred in connection with such action, including attorney's fees, etc. Okay, so this appears to be a clause that's forbidden under Colorado law. We found it, we've identified it, we've floated up to the user. And the big idea here is if we can empower consumers to, if we can empower subject matter experts first to build the screens on the platform and publish the screens on the platform, consumers can come in and for free go in and start to, make sense of, in particular, the high stakes contracts they're being asked to sign by businesses, the payday loans, the leases, the prenuptial agreements, any of the loans, any kind of loan transactions, employment agreements, and the like. These are the high stakes contracts. Whether the terms and conditions matter as much to most consumers remains to be seen. Those tend to be pretty low stakes contracts, but we as individuals sign a number of high stakes contracts in our lives. And our vision, our hope is that, we will build a platform that lets all of us go and take those high stakes contracts and get effectively an expert opinion about what those contracts mean and how favorable or unfavorable they are. Let me pause there. Any questions, comments so far?
I'm wondering, this is incredibly fascinating and innovative, so thank you for sharing. But to hand the microphone back to you, I guess I'm wondering, when you say you're crowdsourcing, are you inviting people to apply to be a subject matter expert and then you screen them, or are you opening it up to anyone who is an attorney or fits your criteria to develop these and publish them. Say a little bit more about your crowdsourcing process.
Yeah, thanks for asking. And yes, we are really eager to meet anybody who wants to publish a screen on the platform. So if anybody in the audience here is saying, wow, I could really do a mediation clause or a dispute resolution clause screen to help people screen those clauses in contracts, for example, that would be amazing. We do want to curate and make sure that the quality of the screens is really high quality. Over time, as we grow as a company, we plan to sort of crowdsource that process, the curation process, like a lot of content apps do. Let the crowd go in and drop comments on screens, you know, and say, hey, this one worked really well. This is a really good screen and the like. In the near term, we've got a small committee of people that are looking at them. And, you know, we want credible folks that are true experts in different fields. And so there's a lightweight process to just quality control both the author and the screen itself before we publish it. But we can help on the quality piece in particular. If you have expertise to bring to the table, we can bring the technical skills and the prompt engineering to help you build a really, really great screen to capture or accomplish what it is you want to capture or accomplish with the platform.
Thank you. Anything else you want as part of your wrap up before we see if there's any last questions?
No, I'll put my email address here while we take final questions, and welcome anybody to email me if you'd like to chat any more about this or have ideas. Like I said, we're in the super early stages of this new company, and especially excited to talk to anybody who's interested in contributing to the community of Screens.
Thank you, Otto. So we've got a couple minutes. Let's see if there's more questions. Let's start with questions for Otto. And maybe if you don't mind stopping screen share, then we can have a chance to see each other and see you. Thanks.
Yeah, Jeffrey? Or no?
Hi, thanks, Otto. Very interesting. So, I come from the settlement and debt area, and that's sort of early on how I got into ADR, ODR, and whatnot. And so my question is, can the screen somehow, if the terms and conditions, because we're all subject to this click wrap, and then we all get put in these positions, and then we get the dispute, and then we're in the dispute, and then folks just need to grab that scale and figure out, is it weighted in their favor, weighted out of their favor? So knowing the terms of the contract and where it's weighted, is there a way to apply the dispute and to figure out how it's going to weight to which party, so they can make a informed decision about resolution, and make the smart decision and settle?
It's a really cool idea, Jeffrey. We don't have that on our roadmap, but it'd be a really cool thing that you could build. Like, we have the first piece of that, which is the piece that helps you understand with high levels of specificity and accuracy the contents of the contract. So somebody could build off of our APIs, for example, the latter half of that, I think, which is now plug in the fact pattern of the dispute and mash those two, pieces together to try to make some predictions or help people assess claims. Really, really cool idea. Be happy to brainstorm on that if you have the entrepreneurial bug, Jeffrey. But
yeah, I do. So our platform's been in development for a while, but it's called EquiSettle and equitable settlements. And so this is sort of the last piece, and we kind of do it by field by using surveys to the parties and having them sort of arrive at that position. But to have some weighted data based on the black and white, you can get Chase Manhattan to say, fine, fold, I'll take 40%. It's not worth taking it to court. That's kind of what we're looking at.
I love it.
In the realm of add-ons, another direction that some entrepreneur might want to go, or you yourself, is the direction of, okay, so now I know, why this contract is bad. What do I do about it? in the sense of whether it's negotiation advice or any other sort of information or guidance. You know, of course, it could be a process of actually bringing people together, but even if it's just geared towards the screener, the person who reviewed it, and now, okay, so what do I do? Often in these cases, there'll be power imbalance. What do I do about it? And so some sort of tailored information, educationally oriented, might be helpful. And that, which leads me to sort of the next of, I don't know what your business model is, but it strikes me that that people who would be interested in contributing, so to speak, both screens and perhaps follow on, is the nonprofit world. Like I can see, folks dealing with housing, wanting to exactly what are bad leases, and what are bad leases in our area, and whether it's based contrasting with statutes or contrasting with local practices that are shady, and they might also have interest in developing. And in various other fields, of course, consumer protection of any sort. It's the nonprofits who say, well, I'd like, we'll dedicate, if this can save, thousands of customers in our area grief. That's exactly the sort of preventative tool that we're looking, instead of having them come to us after things have gone to pieces. So that's where I'd point.
I love it. And that's honestly where we're pointed right now too. We're talking to a lot of nonprofits, legal aid organizations, legal aid clinics, and the like, to develop screens and publish them and launch them for the consumer world. So I love it. It's really great feedback.
I was thinking something similar, Noam, because it reminds me of how contracts and the law so often replicate actually inequalities in society in the name of supposed neutrality or colorblindness or the like. And so nonprofits and advocacy organizations can identify some of that, so that even if something follows the law, there may be other prompts for a consumer or a tenant or the like that they will want to pay attention to, seeing included to provide some protection or increased equality, perhaps. So, and this also speaks to what I think is going to happen more and more in the field, is that dispute resolution through the use of technology, legal tech and mediation tech and arbitration tech, is actually going to become even more interdisciplinary as we reach out to those that don't see themselves as doing dispute resolution work. So if there's another burning question for either Otto or Scott, we can take that. Otherwise, we'll start to head to wrap up.
Not a question, but yet another brilliant presentation. And the theme, self-determination, is in my head from both of these wonderful presentations. So thank you. And I'm going to copy your information as well. Thank you.
Great. Thanks, Tina.
Thank you, everyone. Before I close and let you go, I just want to say there are a number of other fantastic Cyber Week events later today and tomorrow. So I just wanted to point out, for example, for those that want to practice a simulation, I know that Cyber Week Settle's still going on, and if people have not joined the simulation yet but are interested, they're happy to make time to connect with you. In addition, later today, 5 o'clock Eastern, is ODR in Asia, with some discussion of how ODR is manifesting in a number of Asian countries, and it's co-sponsored by the Society of Mediation Professionals in Singapore. And tomorrow, I also want to just mention that there is an opportunity to learn more about AI and ODR, as well as a social hour. So come and help us close out the week together. Thank you. Thank you, Scott. Thank you, Otto. And thank you, everyone who participated.
Thank you all.
Everyone.